Welcome to the Probate Nation. People are living longer thanks to good health care and healthy lifestyles. Yet as we age, not everyone remains as sharp as they were earlier in their life. Frequently, a loved one, a son or a daughter, is called upon to take on the responsibility of helping an elderly parent with their financial and medical decisions. But even more frequently, and unfortunately, that parent has not executed key legal documents to formally authorize that assistance. In part one of this program, we learned much about the legal process you can initiate to acquire that legal authority as a court-appointed guardian and conservator if your parent lives in Prince William County, including the bonding requirements, what needs to go into the pleading to the court, the role of the guardian ad litem, and the court hearing to act on your request. But what was covered in part one is not the end of the story, and tonight in part two, we complete the discussion. We are fortunate to have as our guests again local attorneys with experience in these matters. They will serve as our guides in completing the discussion about all that is involved in the living probate train ride you are seeking to embark on. Our first guest is a partner with the Manassas law firm of Farrell and Croft. Her practice focuses on wills, trusts, estates, probate, long-term care planning, conservatorships, and guardianships. She also serves as a certified guardian ad litem for incapacitated adults. She is a member of the Prince William County Bar Association and the Virginia Women's Attorneys Bar Association and is active with Capital Caring. Our second guest is a partner at the Manassas law firm of Von Keller Thielen. His practice focuses on estate planning, estate litigation, adult conservatorships, and guardianships. He also serves as a certified GAL for incapacitated adults. He is a member of the Prince William County and Fairfax County Bar Associations. Please welcome Andrea Maurici and Joe Thielen. Guys, thanks for coming back. I appreciate you guys taking the time to come back to continue and complete part two of this program. You know what, I think we talked about a lot of the time involved and all the various lawyer time that might be involved in these petitions. And Andrea, there are clearly a host of fees and costs that can and do arise in this entire process. Can you discuss who pays these fees?
The petition is initiated by the petitioner, and generally that person is going to have to retain their counsel and pay upfront a retainer fee. The second costs arise with the guardian ad litem, the person appointed by the court to serve as a counsel for the respondent. That person's fees get approved by the judge and can be paid either from the respondent's estate or by the Commonwealth of Virginia if the individual is indigent. Indigency meaning they have no income or they're only on Social Security with a modest pension, etc. Medical evaluation could be another expense if the person does not regularly see a medical provider. Otherwise, we can generally get a report prepared from the doctor's notes. If the matter gets contested, the judge appoints an attorney for the respondent, and that fee gets paid from the respondent's estate as well. So this could be very expensive with 3 lawyers involved in a contested matter.
Well, that is so true. At the beginning of the part one show, we talked about some of the key legal documents that folks should be sure to execute, documents that might eliminate the need to embark on the living probate train ride. Can you mention those documents again?
Absolutely. We encourage everyone to have what we call the living documents. A general durable power of attorney to help with financial matters for the individual, a living will or a durable medical power of attorney, or even a document called an advanced medical directive. These documents generally name an agent and empower them to act in medical and financial matters, and puts in place the individuals before the time is needed, so they know when and how they need to act.
So Joe, everybody these days are especially cost conscious and thrifty, and of course those are plausible goals and objectives. But in your experience, would you estimate the cost of preparing these very basic documents that Andrea just mentioned, that cost is more or less than the cost of getting somebody appointed to be a guardian or a conservator?
So when we're just talking about the documents, the ones that give the powers for financial powers and medical powers, those are usually not outrageously expensive. Maybe $500 or less for just those documents. If you're doing a whole estate plan, it's more. But any way you look at it, the cost of going through a guardianship proceeding is going to, or a conservatorship proceeding is going to cost more than the cost of preparation of documents in advance. Sometimes, twice as much. Sometimes it could be even more than that, depending on the circumstances.
Okay, well, let's turn now to the appointment in the probate office, and let's continue our discussion. We've been to court. The court has ruled on our petition, and we know that our authority has not yet been conferred on us, and that we need to get to the probate office to complete the process. So, Joe, with the court order in hand, can I head over to the probate office and get appointed as guardian or conservator the day that the court order is entered?
Typically, no. You have to make an appointment with the probate office first, and unless you had the foresight and the ability to get the appointment on the day of court, which is not usually easy to do, the chances are you're going to have to come back on another date after you've made an appointment.
So we have this court order. So what are some of the common reasons why qualification as either a guardian or conservator cannot proceed, apart from bonding issue, which we would have resolved in advance?
Right, so bonding is a big one. Other things are if there are errors in the order or things that needed to be included and were not and need to be corrected. If you don't have all the paperwork filled out correctly, if you, at least in Prince William County, fail to bring a copy of your driver's license, they might tell you to come back another day.
And let's talk about how I go about getting an appointment. Okay, so how quickly can I get an appointment to get in to see the probate office to get qualified?
I think these days it's taking a couple weeks to get an appointment to be able to get in and see the probate office. And then once you do get in the appointment with them, you actually go meet with them face to face, where they set you up with a computer, and then meet with them via computer at that appointment.
Okay, so we did discuss early on, I think in part one, we talked about the need for a bond for a conservator appointment. Will the bonding rep be present or need to be present when the conservator is qualified in the probate office?
They don't need to be present when you are there, but you need to have that process completed and have the bond approved, because you're not going to get qualified unless you have that bond approved. After you go and get qualified, the bonding agency can come by and complete the process from their end at a different time.
Now, Joe, how is the amount of the guardian bond? What is the amount of the guardian bond, and how much? And what is the amount of the conservative bond that we would need to have?
So the amount of the bond is recommended by the guardian ad litem to the court typically, and for a guardian, it is typically about $1,000 unsecured, meaning you don't have to have a surety to I guess back back the bond status. In terms of conservatorship, what we typically do is take all the assets in the estate of that person, multiply by 1.3, so we're 30% more than their total estate, and that is the total dollar amount for the bond, and then the bonding agency would issue the bond on that dollar amount. They are an actual surety, so it is a secured bond.
Now, we've completed that whole process, we've paid our fees. What type of document is given to me to show that I've been appointed guardian or conservator?
You will get a certificate of qualification as a guardian or a conservator, and you will be able to take that document wherever you need to show someone that you have that authority.
And you'll get two different certificates, one for guardian, one for conservator, as I recall. Is that correct?
Yes, sir.
Okay. Andrea, does the probate office provide any written guidance or instructions to these newly minted guardians and conservators?
Yes, the probate office provides the documentation that's required by those individuals to be filed in the future. They have the documents available. There's guidance available on the Prince William County website, and there is also template forms that are provided complete formatted for the individual so they can use those going forward.
Okay. And does the Commissioner of Accounts office provide any written guidance or instructions to these newly appointed conservators?
Yes, the Commissioner's office provides a substantial little booklet of all the requirements that are needed to be covered. For a conservator, this is filing an inventory and an account, and the details on how to do that are included within the in that handbook.
Now, I know we haven't shown it online, but it's a very thick book that the Commissioner puts out, and you can download that from the Prince William County Probate Office website. Andrea, I'm going to turn to the reporting requirements after someone gets appointed. So after being qualified in the probate office, walking out of there with my certificate of qualification, the guardian and conservator do have some ongoing reporting requirements to the Department of Social Services and the Commissioner of Accounts. So what are the reporting obligations to begin with to the Department of Social Services?
Guardians are required to provide a report to the Department of Social Services. This report, the initial report, is done 4 months after you've been appointed. So you send off your initial report, and then a year later, from that point, you're sending in your subsequent annual reports. And the Department of Social Service will work with you and confirm dates that those are required to be filed. The clerk gives you the initial form, again, with your information pre-printed, so you know the technical information from the court that needs to be included. This annual report to the Department of Social Service is the only reporting requirement by a guardian.
Okay, that's good to know. Now, on the other hand, that doesn't seem particularly onerous. On the other hand, there are rather significant reporting obligations to the Commissioner of Accounts. Can you discuss those for us?
Yes, a conservator has quite a bit of responsibility to report their activities. That responsibility begins with an inventory, which is a listing of the assets that are in the hands and custody of the conservator. And they file that report 4 months after qualification. The next report is due 6 months after your qualification, and that report is an account. It covers those first 4 months and tells what did you do with this money, what came into your hands, and how did you use it, and what do you have left. And then annually thereafter, a conservator needs to file an annual accounting with the commissioner. Again, these forms are provided to you, the template forms from the clerk at your appointment, and the instructions by the commissioner's office.
So I just point out to folks that the inventory form that Andrea mentioned is a form that basically is your opening entries for your financial reporting that is going to be ongoing. But the interesting thing about that is it's not required that you document where you got those numbers from, okay? So it just basically is a beginning, but very shortly thereafter, you're going to file an account. Now this account requires you to fill out 10 lines. So you would think it'd be incredibly simple, but it turns out to be much more complicated than you think. But every line has dollar amounts in which you're going to have to document every penny received and every penny spent. And so that becomes a source of great consternation for many people. And I want to just mention that because I think Andrea would agree that this is certainly an area where help is certainly suggested. Continuing with these reporting obligations, to the Commissioner of Accounts, these are things that often lead to trouble and can also result in a conservator being removed or lawsuits against them. So can you review, Andrea, some of the key do's and don'ts that every conservator should follow in order to stay in the Commissioner's good graces?
Yes, as you said, while the form doesn't look very sophisticated, it does require a great deal of information. And so to begin with, it is in your best interest to establish a separate checking account for your conservator. Close prior and open a new fresh one. And then you need to be obtaining bank statements from your bank every month in order to compile that report of the accounting when it comes time. You're going to need copies of canceled checks. The commissioner does not want to see copies of checks you are sending out. They want to see the check that went through the bank and where it got cleared from. Other areas that conservators run into trouble is taking over generous fiduciary fees, paying themselves for doing the job of taking care of the individual. There are guidelines on what you take, and the commissioners are quite serious about these guidelines. Also, conservators run into trouble when they say, oh, mom was always very generous, giving birthday gifts to grandchildren, etc. Gifting becomes a problem. You need permission of the court to make gifts now. So if that's something that's very important to the family, you should have discussed that during the petition and before we had an order entered. Also, being kind of conservative or being shall we say, frugal when you're going out shopping. So you pick up mom's lettuce and milk and coffee and throw it into your grocery list. And then you have to take it out. And the commissioner doesn't believe that that was for mom. Instead, they think that was for you. So really tracking and keeping your respondents' monies separate and keeping track of them. They're very concerned about conservators using the money for themselves or their families, and not so much for the individual who needed the help.
Well, you know, I wanted. That's a very good collection of do's and don'ts, Andrea. I wanted to mention that there are two prior shows. We have done two prior shows covering the preparation and filing of both the conservatorship inventory and the conservatorship accounting. Those guests used to work as auditors in the local Commissioner of Accounts office. So those shows bear watching, whether you prepare these filings yourself or hire someone to help you do so. You can find the shows on the Probate Nation website. Well, let's turn now to get your collective thoughts about some of the common problems and pitfalls. So what do you guys see as the problem areas based upon where we are so far in our discussion tonight in undertaking a request to be appointed a guardian or conservator? Andrea, what do you have to say about that?
My holy grail is communication. A lot of pitfalls for guardians is not keeping family informed about what's going on with mom or dad. So relocating them to a nursing home out of their home, moving them out of state, just the sort of surprise information that family members don't want to get surprised with. They have come to understand there's the disability with this adult that they all love, and they know that somebody needs to be doing and taking care of them, but they always want to know what's going on, where they are. So keeping family informed of particularly significant things, medical issues, housing, things like that.
Joe, how about your thoughts? Some common pitfalls or problem areas you would want to keep people alerted to?
So in the conservatorship arena, I think the biggest thing that people need to realize is that this is not your money. This is somebody else's money and you are in charge of it. And there is the Commissioner of Accounts who's going to be going over everything with a fine-tooth comb, making sure that you haven't had any unauthorized expenditures. And to piggyback off of what Andrea said, communicating with the family, because if you have, if you're taking care of mom or dad and your siblings think you're spending too much money, they may try and challenge how much you're spending and your accountings. And there are a lot of people watching how you use that money, so you have to be very careful about how you use it and make sure you only use it for approved purposes and that you keep track of it very well.
Well, okay, there are a lot of, so I'm going to go to your closing comments where it looks like I see the clock that we're winding down to not too much time left. So there's a lot of moving parts in this process, and this program only scratches the surface as to all that goes into making the process work. Each family situation presents its own set of dynamics and challenges. Hopefully our viewers appreciate that this is a process that should only be initiated with the assistance of legal counsel. It is not something that you should undertake to do on your own. So I'm going to look to Joe, get your final thoughts and words of practical advice, practical suggestions regarding, obtaining appointment as a guardian or conservator in Prince William County.
So, I mean, the first advice is always plan ahead. If you can prepare the estate planning documents that will avoid the process, that's always the best choice, because getting guardianship or conservatorship should be your last resort. The other thing is really talk to your family about it. Make sure that everyone knows what the desires are of everyone else. That way, when you're going to implement a plan, you can accomplish the goals that puts in place.
Andrew, how about yourself? Some final thoughts?
As an attorney who's done quite a number of these over the years, I talk to people and say, your job right now is to be looking after mom and dad, making sure that they're safe, medical needs are provided, that they're not being taken advantage of. Let the lawyers do the legal part while you do your part. This is stressful. Taking care of an adult with disabilities is stressful in a family. So let you handle the personal part. Let us handle the legal part. We can make it more efficient and smoother for you, and than if you try to do it yourself. When you do it yourself, issues arise, and you need a much more additional counsel and advice to get us through the process that we cannot always provide to you, and may still be sending you back to an attorney. Also, know that we have access to resources and can share with you information about other professionals who can be helping you. For instance, care managers who can be helping you coordinate the caregivers coming and going in from your home and the medical needs. CPAs, investment professionals. Also, if it's going to be contested, we are going to seriously encourage you to look for less expensive methods to get this resolved, such as a mediator, because litigation is expensive, and it may not be fair on the parent to burden them with all the legal fees that may arise in the contested case. So plan ahead, but if we have to go through the guardianship conservator course, please seek counsel and let them bear the legal aspects, and you could take on the family aspects.
Those are all very, very strong points to make to people. I want to thank, Andrea Morisi and Joe Thielen for taking the time to talk with us again today and complete part 2 of our discussion. This is a great service to the folks in Prince William County, and certainly to the Prince William County Circuit Court. So hopefully make things go a little more smoother if people decide to petition to become a guardian or conservator. So thank you both again for your great assistance and contribution to this. If you need to petition the Prince William County Circuit Court for the legal authority as a guardian and conservator, what our guests shared over the course of 2 shows should be incredibly helpful. Clearly, there are numerous steps to take to get your request to court so a judge can rule. And many of those steps deal with legal requirements both in the documents filed and in decisions to be made, many of which involve seeking help and guidance from other professionals. My guiding concern as we wrap up these shows is the following. Seeking this authority is not an undertaking you should handle as a pro se petitioner. There simply are too many decisions to be made, too many legal steps that require legal knowledge, and often this is an emotional time for you, the family, and the person you are seeking legal authority to care and act for. I urge you to seek out the assistance of an attorney with experience in these matters before you get in line to purchase a ticket to board the living probate train. You'll be glad you did so. This brings us to the conclusion of our show. I hope it was informative. And remember that replays of both these shows and all shows today can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.